Hi, this is Bay Macfarlane with Mary's Advocates, and Mary's Advocates' job is to reduce unilateral no-fault divorce and support those who are unjustly abandoned. And one of the ways we work to reduce no-fault divorce is to publicize ways that people could use the U.S. Constitution and even states' constitutions to stop unilateral no-fault divorce. And I have with me Matthew Johnston, and the reason I have him is because he has been studying up on this for quite some time. I think I first corresponded with Matthew like 7 years ago. I'm not quite sure. And he's been following very closely a case that's pending right now in the state of Massachusetts, where they have unilateral no-fault divorce. So we published on Mary's Advocates a blog about this not too long ago. And what I've got in front of me is some of the court paperwork. And we also have that posted on Mary's Advocates website, and I'll be giving updates about that as the weeks progress. But for now, for anyone who's interested, I just wanted to go through explaining kind of for two people's perspectives. One audience that this is targeted for is just the average person that knows there's something wrong with no-fault divorce. But secondly, people who are legally minded, lawyers, or people who are just familiar with how the Constitution works. So we're trying to target both audiences because Matthew has been studying this case so deeply. I'm pretty sure he's capable of answering lots more questions than I'm even going to ask. But I'm also going to be trying to pull it through so that just the average person who has a sense that there's something wrong here can also follow what's going along. So Matthew, do you want to tell us a little bit about what's going on in this case right now, and just kind of high level, elevator speech version of what's going on?
Sure, yeah. So Mark reached out to me, and Mark Dallmeyer, who's in the state of Massachusetts, and we've been in communication because he's challenging the no-fault statute, the unilateral no-fault statute in Massachusetts. And so we got in contact so that we can follow the issue. He knew I was very involved in no-fault divorce, as well as you, and trying to publicize his case. And so I took a look at what he's doing, and it's really remarkable. And it's kind of like a recent case that took place in Pennsylvania, but it's approaching it slightly differently. But in essence, his wife filed for divorce about 2 years ago, which is quite a while, and they still don't have the divorce yet, and they haven't gone to trial yet. And so he wanted to challenge the unilateral no-fault divorce in Massachusetts. And of course, I mean, if you're in any state of the 48 states of 50 that have unilateral no-fault divorce, you know that there's no defense to the no-fault grounds. And so basically it's a guaranteed foregone conclusion that the divorce will take place. It's just that the settlements have to be, negotiated about, marital distribution, marital estate, and custody. But essentially the no-fault is guaranteed. So, and the judge told him this too. I mean, when he tried to contest the divorce itself, the judge said, well, I mean, it's no fault. It's unilateral no fault. You can't do anything about it.
Matthew, let me cut you off here so for the person who wants to make sure they're following. In the old days, the only way you could get a divorce is if you had grounds. The defendant, the person to whom you're accusing that you need a divorce against, had done something bad enough to justify, and I come from a Catholic perspective, they've justified something that merits permanent separation of spouses. Adultery is one of those things. Extreme danger is one of those things. Marital abandonment is one of those things. So in the old days, if a woman was abandoned by her husband because he's out having an affair with somebody, she could file a divorce against him, but the court would give a remedy to make her situation better than it had been prior to whatever was going on. And then his situation would just be that he's being held accountable to uphold the promises he made at the time of marriage. So this kind of no fault that we're talking about, it's when one party just goes to the court and says, different states have different versions of this. Some states have waiting periods where the person has to be separated for a number of months. Other states have no necessary waiting period that has anything to do with defining the reason the court will grant the divorce. And that's what Massachusetts is, where she just comes forward and says irretrievable breakdown or irreconcilable differences or incompatibility. And the mere fact that a plaintiff alleges that means the state has power to take over property, children, and come up with some kind of support plan. So for a defendant who's done nothing like adultery or being dangerous or abandonment, they have their children and their property taken, however much time the court might decide, and they're faced with this choice. I call it coercion, because a defendant in a no-fault divorce is faced with a very terrible choice. I either agree on paper to something I don't agree to at all, on how I'm going to lose my children and lose my property some of the time, most or all, and I will be civilly divorced. But on paper, it was an agreement. That's a coerced agreement. The option is to say, I don't agree to a divorce, but then the person who's asking for the divorce gets to tell the court, well, this is what I want done with children and property and support. And then the court will do whatever the court does. So that's just kind of some background of where this is all coming from. So go on and continue with what you were saying about what is it that Mark Dallmeyer is what's the basis of what he's talking about, just kind of high level before we go through the paperwork.
Sure, yeah. I mean, as you said, in the old days, there needed to be essentially fault-based grounds. And what that means is that there's a threshold where the civil state says, okay, there's a way to liberate yourself from the marriage, so to speak, and not talking in religious terms, but the civil government provides a remedy or a liberation from the marriage status, because there's a threshold behavior that the state says, okay, this is a reason that you can get separated. With the introduction of no-fault divorce in the 1960s, 1970s during the sexual revolution, they replaced this system of fault-based grounds with no-fault. And there are two types of no-fault, and it's important to understand the difference. One is no-fault by mutual consent, where neither party has to allege misconduct, but both parties do have to agree and sign on paper. And then there's unilateral no-fault, which is the vast majority of the situation, which is, as you said, coercion. And I like the little phrase "divorce by force," but essentially, there's nothing that you can do about it. And so, where the settlement, really, what we're talking about is the legal status, right? And once the legal status is dissolved, then the government can redistribute the wealth, redistribute the custody, and so it's really important that the status is protected somehow. And
you mean marriage status?
Yeah, marriage status. And what fault-based grounds did, it wasn't really about pointing the finger at people. It was really putting a limitation on the reasons you could get divorced, so that the status of marriage is protected in some way, because you needed to reach some threshold. But with unilateral no fault, there doesn't need to be any other threshold than, like you said, just the allegation alone that the marriage is irretrievably broken. So what we're talking about is really the means and methods for dissolving the status, because once you do that, your entire life gets opened up to the government. And what are some of the principles that Mark is using to tell the state? Because what's happening here is a constitutional challenge. It's Mark's coming forward and he's saying, oh, by the way, Judge, this law that you're used to forcing divorces on people, this Massachusetts law itself is an illegal law. It's an unconstitutional law. And there's plenty of reasons why a defendant could say something like that. So can you tell the viewers what are the reasons that Mark is using? Yeah, so in a no-fault proceeding, the judge most of the time makes very clear there are no defenses against no fault. Well, there is a defense, technically speaking, that you can challenge the law itself and say that it is an illegal law. And, well, how do you do that? Well, you appeal to a higher law. So, state legislatures, lawmakers, politicians, they pass laws all the time. And honestly, there was a Supreme Court judge in Oregon or the state of Washington that said most laws that are passed are actually unconstitutional. But you can't challenge it unless you're actually in the case, have a case in controversy. You're in a proceeding, and that gives you the ability to challenge it. So with this assumption that there are certain laws that are unconstitutional, Mark is challenging that the no-fault statute is unconstitutional. And so he's appealing to a much higher law, which is to say that, yes, the state legislature can pass laws, but they have to pass laws within the limitation of their state constitution and within the limitations placed on by the U.S. Constitution. So, yes, legislatures can pass laws, but there are limitations of what kind of laws can be passed, right? And so he's coming at this from the perspective that the no-fault statute is unconstitutional. Now, there have been many cases in the 60s and 70s that have attempted to do this, but he's approaching it from a different way. And one of the things that's important to understand is that the no-fault law is based on a certain ideology that, you know, if you look back into its history, was really a communist, Marxist-Leninist ideology of undermining the family through ideological means. I mean, most of the legal system of the Bolsheviks were ideological in nature and didn't really follow a rule of law. It was based on, well, does it comport to Marxist-Leninist ideology? And so with that kind of theoretical background, you can now look at no fault in a much different way, because the allegation that a marriage is irretrievably broken is a matter of someone's opinion. It's not, you know, you talk about fault, but really what is fault? It's some kind of conduct or action that someone does. And so really all the laws in our country have to do with what you can and cannot do, right? All our entire legal system is based on what are you allowed to do, what are you not allowed to do.
And you keep using the word do. I'm going to emphasize that, because the word do is important in contrast to the word feel or think.
Exactly. And that's really the crux of Mark's argument in Massachusetts, which has never been argued before in any constitutional challenge to no fault. And so what we're trying to do is make a distinction between no-fault divorce and fault-based divorce, because everyone just says, well, irretrievable breakdown is just another ground. Well, if you can make a distinction and isolate no fault from the other grounds that have historically been, you know, in operation, then you can maybe make the challenge constitutionally why this one is different. And so what Mark is saying is that, you know, if you had a divorce ground based on adultery, well, basically the law is saying that you shouldn't commit adultery, right? If the divorce law says you can't abandon or desert a spouse, the law is basically saying you shouldn't desert or abandon your spouse, and domestic violence and the rest.
And I want to add, if you were to do those things, the victim or the parties and the children aggrieved by whatever is occurring are seeking a relief to make the situation better, and the perpetrator is obligated to do some kind of reparation. That's what it used to be.
Right. And so if you're trying to escape that condition where either you've been abandoned or there's domestic violence, the idea is that you're given a relief to be liberated from that situation. And if you're, you know, in those situations, most likely you don't have access to the resources within the marital relationship. And so that's why there's division of finances and custody.
And I think most listeners who are at least interested in this topic are kind of, they're hearing all this and it's resonating, like, yeah, I know. So what I'm excited about is what is it that Mark's doing to say why this is unconstitutional? Because, like, people, maybe they've read the Bill of Rights or they looked at the amendments, you know, but you don't really know. And I know you know more than I know. So, what are the key things that he's using to throw at this law, saying the whole law itself is unconstitutional?
So the fundamental argument that he's saying is that because this is an ideological statute, he's claiming, he's arguing that the no-fault statute is basically a viewpoint-based statute, or a viewpoint-based law. And that's important because there have been viewpoint-based laws in the past, and certainly more recently, there's been a lot more of that. So if you think about the recent Supreme Court case with the baker, the cake shop baker in Colorado. The issue was that he was being compelled to express a message through baking a cake for, a homosexual couple. He was forced to do that and express that message against his own beliefs and his own viewpoint. There are other cases, like there was one back in the about the Pledge of Allegiance and whether a state could compel people to stand up, salute, recite the Pledge of Allegiance, even if that was not what they believed. And so that law was struck down because the state was compelling this viewpoint on people who didn't share that viewpoint.
I want to add something to throw in here just to make it lower it down. Say I hired somebody to make me a countertop that was a certain shape, and I gave him a drawing with specifications about the shape of things with inches and pluses and minuses. It needs to be 20.5 inches deep, plus or minus an eighth of an inch, and it needs to have this oval cut into it. And then the guy comes back and he gives me exactly what was in the drawings, and I sue him and say, I'm just really unhappy about this. It doesn't look the way I want it to look. I feel bad about it. This is just, it's just like this is impossible for me to accept. So it's my opinion that it's impossible for me to accept. But if you compare his actions to what was written, it's just fine. And if someone people know that's insane. That would never work. The culture would fall apart. If I could bring someone to court to just say, I just don't feel the way I thought I would feel, or I expected to feel. It's stupid.
Well, and that goes back to the difference between doing and thinking or doing and feeling, because the issue with the cake shop baker was not that they agreed on the specifications. It was that he was forced to communicate a message that he did not agree with, right? So if we take this to Mark's argument now about irretrievable breakdown, his wife is alleging that the marriage is irretrievably broken. He's alleging that it's not irretrievably broken, right? Those are a matter of two different messages, two different viewpoints, right? It's not a law about what you're doing or what action or misconduct that you've done. It's a state of mind. It's to say, my view is that the marriage is irretrievably broken. My view is that it's not irretrievably broken. Now, so what he's arguing is that this sets up I'm terrible at idioms, but this sets up basically a rock in a hard place for the court, because now the court is not making a decision based on someone's conduct. The court is now forced to endorse one of these viewpoints. Is the court going to side with the wife's opinion, or is the court going to side with Mark's opinion? Well, Mark's argument is that either one would be unconstitutional, because the court can't make decisions based on someone's mere opinion, and laws cannot exist to regulate people's mere opinions. And there's plenty of case law, there's plenty of cases that the Supreme Court has dealt with to say that the limitations placed on lawmakers is that they can only make laws that target people's conduct. They cannot make laws that target people's opinions, beliefs, viewpoints, feelings. And there was a recent case in Massachusetts, in fact, that was all about viewpoint, because the city of Boston allowed people to wave flags that communicated messages about, whatever they represented, but they excluded a Christian or a Protestant flag, to raise. And so, why did the government allow certain opinions and certain viewpoints to be expressed, but not others? And when it went to the Supreme Court, it was a 9-0. So even the liberal justices said, no way, Jose, you cannot regulate someone's viewpoint.
Okay.
And so really the burden is on the court now to say, no, the no-fault law, it regulates conduct. It doesn't regulate viewpoint. So now they have to prove that it does regulate conduct. And we already know from 50 years of court cases that courts around the country already admit that no fault does not target conduct.
Okay, this is a good break point from discussing the principles that are involved here, and I want to get into the actual documents that we're going back and forth in the court, because
Sure.
I think that will get a lot of the questions answered that are more legalese that maybe the average person doesn't have any interest in, or they're just curious about it, and I want to help it be more understandable. So what I've got here is I printed out the documents so far that have gone with the wife's complaint for the divorce, and then Mark's action to the judge where he submitted a motion to have it dismissed, and then when Mark did that, if a resident of the state is challenging that a state law is unconstitutional, the state itself is kind of put in a position of defending their laws, so one has to advise the state attorney general. So I've got some excerpts from what Mark submitted to the state attorney general, and I would just like to start going through those. I kind of marked them up. I was studying them before we did this, so that we can just talk about them.
Sure.
So,
yeah. We can start from step one, which is, her original complaint back in October of 2020.
Yeah, and I wanted to ask you something about that.
Yeah.
Because in Massachusetts, she stated she was granting a divorce for this certain section of the law, which we know is the unilateral no fault. Do you think, this is kind of a tangent, I didn't give you warning on this one. I'm very familiar with Ohio's divorce law, and in Ohio, the judge is measuring whether the parties have factually been separated for a year. So in Ohio, the no fault forced ground is the parties being separated for a year, and that is an action. It's something that somebody did. Where in Massachusetts, you don't even have to be that; it's just purely the opinion.
Yeah. So the way that I've seen no fault laws around the country is the situation in Massachusetts is unique in that they have two statutes for no fault, and one is very clearly mutual, and one is very clearly unilateral. In many parts of the country, there's one no fault law, and it's ambiguous of whether it's unilateral or mutual. But one very easy way to tell is if it says that either party can allege or one party can allege, that's what makes it unilateral. If it says both parties must allege, that's what makes it mutual. So that's a nice trick to see whether it's actually unilateral or mutual. But basically, it's under one statute. And then other cases, like you said, require a 1 year waiting period or a 2 year waiting period. The issue with that is that, according to the Equal Protection Clause, two people have to be treated equally under the law if they are similarly situated. And so what that means is, in an abandonment or a desertion case, one party very clearly, left or abandoned the other spouse. But in the case of both parties being separated, it's unclear, and both parties are similarly situated. So there's no difference between one spouse who's been separated a year and the other spouse that's been separated for a year. And so really the only distinction goes back to whether they think it's irretrievably broken, because both parties are separated. So the decision isn't based on a 1 year, if that makes sense.
You know what I mean? They just go in and say, let's testify how many months have you been apart? And then it's like, yeah, I've been apart for 13 months. And then the other party goes up and says, how many months you've been apart. So both parties admit on the record the fact that they've been separated for a year, but nobody's interested in whether the defendant was pleading with the plaintiff to come home the whole time.
Well, not only that, but legal cases there has to be a case in controversy, right? There has to be a disagreement. If you say that the parties have been separated for 1 year, I mean, both parties agree with that, right? So that's not controversial. The disagreement is whether it's irretrievably broken after that 1 year. So if that makes sense.
Because that's their proof. The proof that it's irretrievably broken is, once they've been separated for a year, now we have our proof. But they use but that's
still a viewpoint, right? Because as a Catholic or as an Orthodox or Protestant, their view is well, it doesn't matter if it's been 1 year; it's still retrieval, it's still reconcilable.
All right. right. Well, I'm going to cut myself off on this line of reasoning.
No. I'm not being.
Part of it is, in the interest of time, I would like to cover this case, and it would be fun to see. Fun. That's kind of the wrong word. It would be very interesting to see someone in a state like Ohio, where they're not saying the ground is irretrievable breakdown. They're saying the ground is separate and apart for a year. But the truth is, one person is pleading for the plaintiff to come home, and the plaintiff's like, I'm out of here. I'm forcing a no-fault divorce on you because I've been out for a year. So let's move on to this paperwork.
The short answer is yes. You can still challenge a no-fault law even if there's a 1 or 2 year separation. Okay,
cool. So in this case, the complaint for divorce, I don't see anything too much notable about it, except it has no affidavit, no facts, nothing other than we're married and I want to use this ground for divorce.
Right. Yeah. So in the original complaint, it says, and part of this is filled in by the form, it's not even her, but it says, on or about February 12, 2020, the defendant and plaintiff's marriage suffered an irretrievable breakdown. Right. So that's the allegation. That's it.
Yeah. It's you're reading right in the middle of it. It's just a form where you you type a line.
Well, and I don't think we have these documents, but Mark did respond and say, no, it is not irretrievable. So, right there you have her allegation and his allegation. Now, for the legalese out there, this is called the conclusion of law because it's not stating any real facts. I mean, maybe February 12th, 2020, but she's alleging an irretrievable breakdown. Well, that's the conclusion of the law. That's not necessarily factual. Right. And so the court's job is to find out what is factual and then apply the law to the facts. But that's, so it's just right out the gate. It's a weird way to allege an irretrievable breakdown. But anyway, so then 2 years later, he files this.
Can you pause on that one?
Yeah.
Because I was very interested in the next one I have here is an excerpt from what Mark submitted to the state attorney general. It was just a page of that section of the law itself. And the thing that jumped out at me, we've already talked about it, the law itself says causes for divorce, irretrievable breakdown. We talked about that. But then near the middle, near the bottom, it's talking about how even before a trial, the court has the power. Nothing in the foregoing shall prevent the court at any time prior to judgment from making temporary orders for custody, support, maintenance, other such temporary orders as it deems appropriate, including referrals of the parties and children, if any, for marriage or family counseling. I underlined the word counseling in red because every time I've talked to anyone who's a divorce defendant, divorce court ordered counseling is not reconciliation counseling. It's counseling on how to coerce the defendant and the children who think the divorce is hurting them to agree, oh, this is fine, we can be okay. It's just kind of like, the rain came and I got my boot wet in the mud.
Oh, interesting.
It's not counseling about reconciling. It's counseling about making you quit telling your kids that you want your wife to come back to restore the family and be like it used to be. Don't say that. Yeah. And then it's also just abhorrent that they can make these laws. They can make these orders. This is where they make orders about property and children and take over property and children, which is really, really a fundamental right. And there's nothing foregoing them from doing that. Am I reading this correctly, do you think?
Yeah, I think you're referring to the language of the statute. And, some states just say irretrievable breakdown. This happens to be, 8 paragraphs long. Which again doesn't mean, all of these things are procedural, right? They're not about the cause of action. The cause is irretrievable breakdown, but then all of these things, well, this has to be done first, and this has to be done, and it's all fluff. But that's why the legal status of marriage is so important to protect, because as soon as you open that up, then it's what's called an equitable decision. And equitable, it means what the judge thinks is fair. Now, if the judge doesn't like you, it's not going to be fair. But in theory, these are equitable things because you're splitting the baby in half, and you have to figure out how to, quote unquote, fairly distribute that between the parties. But Mark's argument, and many of us know this, is that before you split the baby, you have to decide whether you have to get rid of the baby first. And that's well.
You mean split the baby?
Yeah. Why is there a disagreement about this?
This is so symbolic. We might be losing people. How about before we split who's going to live where, before we decide who's going to keep the marital home, we have to do something. What is that something?
Well, the something is the status of marriage, right? So the status is considered a legal status, right? And so, again, the people that work on this, and Mark in this case, he's focused on, well, before you can even split anything, let's talk about why you're altering and dissolving the legal status. And that is a legal question. There have to be legal principles. It's not about what's fair. It's about, does he have a legal right to be married? Yes. Is there a legal justification to dissolve that? And that's why no fault is problematic, because in these other cases of fault-based grounds, yeah, there is a legal justification because you committed adultery, you deserted, but under a no fault, there is not a legal justification. So even before we talk about splitting anything, his focus is on, well, how are you changing my status from married to unmarried?
Okay, and then these other stuff about, like, if you're married and you have a home that's maritally owned, it's understood, both even in common sense, but I'm pretty sure it's in law too. If my husband and I own a home, I'm allowed to go into the house. If I'm an axe murderer, maybe my husband will call the police and say, my wife's gone nuts, she's running around the house, axes, and she's trying to hurt me and the kids, and the police will come in and take me away, and everyone knows that makes sense. So, but barring that kind of problem, if two people own a marital home, of course, either one of them can go in and out of the house whenever they feel like it. Right. And with the thing that jumped out at me about this, and you make the point that it's kind of administrative, it's not even law. It's like, oh, they can make an order to kick mom or dad out of the house just because one part said irretrievable breakdown, even before we have a trial. Right. So that's jumped out at me in that one. And then the next thing I have here, how many pages is the brief? I mean, the motion. I think it's like 13 or... Okay, it's 10. 10 pages was the last page number on the defendant's motion to dismiss. If I got the page numbers about right.
Yeah, the motion to dismiss isn't very long, but what it says is that, Mark thinks that the statute is unconstitutional and illegal, and if the statute is unconstitutional, then the court doesn't have power to grant a divorce under this law. If the law is not a law, then you can't grant a divorce under this law. So what that means is, if the court does not have authority, it means that the court lacks subject matter jurisdiction. Now, that's important because if the court lacks subject matter jurisdiction, number one, they don't have authority to grant this divorce under this law. And number two, they have to prove that they do, right? The burden of proof is on the court, not on Mark. So it's not a very long brief, but it says, he thinks that this is unconstitutional, and these are the reasons why.
And if we go through that, because literally what I did, Mark, is I kind of went through it and I noticed certain things that I just wanted to kind of go through it page by page. And if a listener wanted to go through it, they could, because we're going to keep updating this stuff on Mary's Advocates. Because you've talked about a lot of it. So defendant's motion to dismiss, a motion is just when a party asks the court to do something or other. Mm-hmm. You submit a motion as compared to the initial complaint. And so Mark's asking him to dismiss the whole case. He has an introduction that gives a high level as to why. And there's two things that were bullet pointed: failure to state a claim upon which the relief can be granted, and lack of jurisdiction over subject matter. Mark, do you think you could explain in regular people speak, what does failure to state a claim upon which relief can be granted even mean?
Sure. So the failure to state a claim upon which relief can be granted goes back to the plaintiff's initial allegation that the marriage is irretrievably broken. So it all goes back to that, and it says, based on that, assuming that it's true, or assuming that she made the correct allegation.
And can I cut you off here, because I think you're answering the question about Mark, and I'm asking the question just more on principle.
Okay.
What is it?
Sure.
What in principle does it even mean? Failure to state a claim on which relief can be granted, or even come up with some ridiculous example so it's kind of obvious what it means?
In principle, it means that there was some fundamental error in her initial allegation in the complaint.
So if I made a complaint against you that had a fundamental error, then the court would say...
very simple example would be, she's seeking a divorce under the statute, but she claims, he broke the speed limit. Okay, it has nothing to do with what you're asking, right? Or he left the dishes in the sink. Well, there's no relief for that. There's no legal relief for that.
Okay, maybe I can use my stupid example about the countertop throughout this discussion. Because if I went to the court and said, I'm suing them because I'm displeased with the countertop, and here's the specs and here's the photos overlaid on each other, and I'm just displeased, I don't feel as happy about it as I expected to feel, they would throw that out. Would that be an example of, I didn't state any claim upon which relief can be granted? There's no law that says that if you're not as happy about it as you thought you might be, that you automatically get to sue the person?
So in principle, there has to be a correct claim, and there also has to be a legal remedy for that. So she has to state a factual claim. In this case, she didn't state a factual claim, she stated a conclusion of law, which is different. And furthermore, the court has to, in order to grant relief, there has to be a legal violation of the right that exists. And no fault does not create any right, and there's no violation of that right. So in essence, Mark is revealing kind of the nature of the design of the no-fault statute, which is that it's an entitlement to divorce, but it's not a legal right to divorce, because in order to have a legal right, there has to be a violation and of something. It doesn't even have to be a physical injury, but there has to be a right that you violated in order to establish standing, which means that she can even bring the claim itself. So what he's saying essentially is that there has to be a violation in order for her to even bring this case.
Okay.
Now, everyone, the judges have always said, well, no fault is no fault. There doesn't need to be a violation. But according to our system of law, there has to be a violation of that right.
That raises a question. Next to the bullet point, he shows R Civ P12B6. Is that Massachusetts state?
That's specifically Massachusetts. Every state has their, procedural way to bring.
Okay, so this is their rule of civil procedure.
Yeah.
Okay. So in Ohio, we have Ohio rules of civil procedure, and they'll say you have to do this. And that would be a reason to say he shouldn't even be here. They should know better.
In Ohio, Texas, California, you can also bring a failure to state a claim upon which relief can be granted. It's just a different, notation.
Okay. And then the next one is lack of jurisdiction over the subject matter. So you've got another, we see another rule of civil procedure, lack of jurisdiction over subject matter. That's going to be in every state, including federal courts. Is there a way to explain that? Simply using not legalese?
So the judge has to make a decision based on a law, and if that law is unconstitutional under every situation and circumstance, then the law does not give him that authority, if that makes sense.
Yeah, so if I live in a municipality and they made some law that was blatantly unconstitutional to the people who knew that. The legislators in my little municipality didn't know that. They thought they had unlimited power to do whatever the heck they felt like.
Right.
So
which is
I would be accused of breaking this local law, and I could go to the court and I might say, the reason you, municipal court, don't have jurisdiction over the subject matter is because this law itself is totally unconstitutional. And if it is, you actually don't have subject matter jurisdiction. So we need to get that figured out before anything more happens here.
Right. Think about it this way. If someone is making a decision based on that law has to be valid. If the law is invalid, then the basis by which they're making that decision is also invalid.
Right. They can't fine me. They can't make me serve time. or whatever they make me pay somebody something.
Yeah,
okay,
but you
okay,
can't
that
just
covers the bullet
willy-nilly,
points.
you can't just willy-nilly say a law is unconstitutional. Number one, you have to be involved in a current case, and you have to, adequately argue why it's unconstitutional.
Well, theoretically, right.
Theoretically.
You can't make any ground. You can't correct any problems. I guess you could convince the legislator, but that's a different matter.
It's a different process, but
yeah. So this process now that Mark is in is because he has an active case. He's in a position to make this challenge and put this information in front of the local court judge. And so then I flip over to page 2.
And just real quick too, I mean, we haven't talked about this, and I know we're running out of time, but his argument that it's a viewpoint-based statute, so a lot of the recent case law actually says that's done under the speech clause of the First Amendment. And the reason that it's under the speech clause is because there's a message that's being communicated, right? So the speech clause, I mean, it could be written, it could be expressed in some other way, like the cake shop baker. But basically, she's expressing her speech. She's using her speech to express the message that the marriage is irretrievably broken. And he's using speech to express the message that it's not irretrievably broken. And so the court has to discriminate or, make a decision based on one of the parties' expression of this message. That's why it's considered under the speech clause. So, so I just want to make that clear, because people are like, well, how is a viewpoint-based statute unconstitutional? It's actually used under the speech clause.
Okay. That's good to know. So then the next thing I had, you talked a little bit about standing. You're talking about viewpoint. They were married at a certain time. That's the factual stuff. And then there's a whole section that he has that's about bullet point number 1. Failure to state a claim upon which relief can be granted. You've talked about, I'm just looking over here, the things that you mentioned something. I'm talking and reading at the same time. It doesn't work. When I made these notes, we're talking about whatever we're talking about, so I'm skipping over things we already talked about. On page 3, I circled the word conclusory allegation, and earlier you had said for the lawyers that she's already making a conclusion of law. Can you elaborate what that means and why and how that applies to what Mark's doing?
Yeah, so judges have 2 roles. They're the fact finder, or in the case of a jury, they're the fact finder, and then there's the judge who applies the law. So you have the facts of the circumstances, and then you apply the law to those facts. Now, the law says the cause of action in law is, okay, the marriage is irretrievably broken. And what was the wife's allegation? The marriage is irretrievably broken. So, that's a conclusory allegation. She's making that conclusion herself without explaining the circumstances that make it irretrievable, make it true. So the court doesn't even have anything at its disposal to see whether the factual circumstances, can invoke this law, essentially.
Okay. And then you talked about injury of fact, talked about allegation wrongdoing, plaintiffs lack standing. Have we talked about standing yet? What does that even mean to have standing in a court?
So standing is the ability to bring a case. And so, let's pretend, let's use a different divorce statute that is, valid. Well, in normal circumstances, someone can use that. But let's say, she alleges that there was adultery and there was never adultery. Well, she doesn't have standing because it never happened. So she can't use that law when the circumstances surrounding that don't exist.
I've seen standing. When I first started learning about what standing was, certain people don't even have standing to bring a complaint. Like, I can't go to the divorce court downtown and say, oh, I'm raising a complaint that it's unconstitutional. I don't have standing. Only a certain person in a certain circumstance has the right to pester the court with the court's time, and they have to have something based in law.
That's a better example, and it's like you don't have standing to sue on someone else's behalf, right? You can only sue on your own behalf. That would be an example.
And then maybe there's lots of case law that talks about what does it mean to someone have standing or not have standing. And if they don't have standing, they definitely shouldn't be in front of a court. And one of the reasons they don't have standing is because it's a void law. or they never.
Yes,
there's lots of things involved in that.
The other reason she doesn't have standing is because she's not even alleging that he violated any of her rights.
True. Okay, so that touches on standing. This stuff, threefold. The established legal standing is threefold. They must have suffered an injury of fact, so we talked about that. The second one, there must be a causal connection between the injury and the conduct. So if my husband was an adulterer, I'm injured by his conduct. And thirdly, it must be likely as opposed to merely, third, it must be likely, that's the injury, as opposed to merely speculative, that the injury will be redressed by favorable decision. I know I was butchering that when I was reading it, but I'm just thinking of some other kind of thing that somebody might sue somebody on a civil court. Let's say the guy who made me my countertop really did botch the job terribly. So I'm injured because he's suing me for the money, and I'm saying I don't need to pay you. So we're both claiming we're injured by the other person. And if he made a good counter and I refuse to pay him, well, then he's injured. If he made a crappy counter and he's expecting me to pay him, then I'm injured. And will I be redressed by a favorable decision?
Mm-hmm.
So the favorable decision would be like, sorry, Mr. Countertop guy, this is a ridiculous countertop. And I'm using this because this actually happened with me. So it's really easy to talk about.
But you get some kind of
it's like common
compensation
sense that it redresses, it solves something, it fixes something.
Yeah.
Okay. So that was number 5.
I mean, that's a pretty standard requirement for standing. And, the fact that lawyers and courts would say, well, no fault doesn't mean that you have to have this. Well, that's just throwing out our entire legal system at that point.
Which is what the problem is.
What the problem is.
Okay, I jump over to page 4. I've got underlying jurisdiction. We kind of talked about that. No subject matter. I think we touched on that enough. Duty. Oh, this business about duty. And this is a quote from some other case law that Mark has in here. Every judicial action must involve the following elements. So it's got a colon and then a primary right possessed by the plaintiff and a corresponding primary duty devolving upon the defendant. How does no fault make this impossible?
In any other law or regulatory law that exists in this country, the law either demands you to do something or it asks you not to do something, right? And then someone else has the duty to act accordingly. And if they don't, then there's a remedial right to, let's say, get divorced, and there's a remedial
duties and rights correspond.
Yeah, duties and rights correspond. So if there's a legal right to something, that means there's a duty on the other person to behave a certain way. If that makes sense.
Yeah.
And if
so
they don't,
no
if
fault,
they don't behave a certain way, then there's kind of a remedy to that.
Right.
But with no fault, it doesn't impose any duty on the defendant, right? It's not asking him to act a certain way.
And bringing in something interesting about Ohio law that supports the Catholic Church's understanding of marriage. Ohio law says something about, kind of defines marriage. It's very short, but it does say mutual support.
Mm-hmm.
And in the Catholic world, mutual support is part of marriage. And if someone abandons, they are reneging on this obligation to support a marital household, whether it be money or time, children, child care, maintenance, whatever. If they pull out and they're contributing nothing, there's a duty. And the other person has a right to share in that duty. So,
right. So the law has everything to do with rights, duties, and obligations. And the problem with no fault is that it does not create a right, it does not create a duty, and it does not create an obligation.
And that's really sad. I mean, in the sense that anyone who knows anyone that's been married more than like a couple months, it's like, there's forgiveness, there's growing in virtue, there's figuring things out. There's going to be days when people are really ticked off at each other and they might be screaming and having temper tantrums or whatever they're doing. I mean, that's just humanity. And anyone who's been married a long time knows that that's part of marriage. So to say when someone feels incompatible is a ground for divorce,
Well,
that's
there
like,
was an
okay, well, then
interesting.
we just got rid of, we just basically erased marriage. Anyways,
We
that's a
erased
tangent.
marriage, and I saw an interesting thing posted on Twitter that said, "No fault divorce?" Question mark. Oh, you mean dating? Because if you can leave whenever you want to, then there's not really a
Rights or obligations.
rights or obligations at all. Yeah.
Or the whole movement. Stephen Baskerville talks about it. I'm not going to go into it. Let me keep moving here because I want to try to not keep this going too long. Now I'm on page 4. The other bullet point: constitutional challenge of state statute and lack of jurisdiction and subject matter. Grounds for divorce are thus statutory and do not exist at common law. Could you explain what common law is? Because I've tried this one in the past and it just doesn't stick.
Well, this is really an important point, right? Because our our British American legal system is based on common law, where everything is kind of morphed and developed and changed based on previous precedent. So you have a law, but it kind of is shaped by circumstances and different times, and it's kind of always in this kind of state of evolution. That yes, there's a legal kind of base core. There's a core, but it kind of develops over time based on precedent. And so think about when you enter into marriage. Well, there's nothing that you can do to kind of reverse that unless the legislature passes a law for divorce grounds, right? If let's say the legislature didn't pass any divorce grounds, well, how would you get divorced then? How is it possible? You can naturally enter into a marriage, but how do you naturally exit? You can't naturally exit unless there's a law to allow you to do that. So, I mean, I know it's not really the case probably in Catholicism, but there are states like in Texas where they still recognize common law. So if you live with someone and your community recognizes that you're together over a long period of time, they actually recognize that you are legally married. But there's no way.
Is this talking about common law marriage then? Or is it
It's
talking about
related.
the concept of common law?
Well, in his brief, it's the concept of common law.
Okay. Well, I think this is getting a little bit too hard to explain.
Sure.
So for the people who followed everything you said, this is good. But I'm still like, okay, it kind of morphs and changes, and in contrast to some other kind of law.
Yeah. Well, the point, I guess, the overall point is that you can't get divorced unless the government creates a way for you to get divorced, right? So, in that sense, it is a creature of the state, right?
Oh, that's why it says statutory. Statutory.
Yeah, common law kind of. Common law is kind of based on natural law, as you would understand it in Catholicism. In a way, it kind of follows that like mentality, but you can't get divorced. There's no way to get divorced. So the state has to create a means for you to get divorced.
Okay.
That's why like divorce doesn't naturally occur. It occurs because of the existence of the state government. It can't naturally occur.
And now I'm reading the sentence more carefully. Grounds for divorce are statutory. That's the big piece that's relevant in my mind. That's understandable, because I know what statutory means. Some guys got together, or people got together at a legislature, and they made statutes. So that's how we are right now.
Well, and the reason that's important in his brief is to say that, I mean, lawyers are going to say, oh, well, he's going to get divorced anyway. It doesn't matter if it's this statute, that statute. I mean, just let him have, but it's like, no, you can only get divorced based on the law that was passed. I guess that's what I mean by statutory rather than like a common law where, it's just some general ability to get divorced. No, there has to be this specific reason.
Okay. And then I flip over to page 5. We've talked about viewpoint. Fundamental due process. Here's one. So this is kind of like the middle of page 5. Where does this sentence start? That's a long sentence. Well, thus, the legislation is invalid under all sets of circumstances since the inescapable flaw is that the law lacks a prescribed rule of action and instead endorses the outcome that requires the court to discriminate between viewpoints. Moreover, the statute is designed to eliminate fundamental due process, as the legislative intent was to render the action for divorce uncontestable. Because in the beginning of some people's divorce experience, they might feel like, oh, I've heard this thing due process thrown around a lot. And other people will say, well, you're in front of a judge. Of course you're getting court due process because you're there. The fact that you're there, people think, well, that's court due process. So where is that kind of thinking erroneous?
Yeah, well, and I based on some of my analysis of other cases that argue due process, they don't really go into specific of what due process requires. And just to give a brief overview, not to get too much in the weeds, if you actually go to Massachusetts Constitution, Article 12, it actually gives a little bit more insight into what due process requires. So it actually says every subject shall have a right to produce all proofs that may be favorable to him.
Wow. Proofs that may be favorable don't exist when someone says, I feel it's irretrievably broken.
So you can sit up and rant and rave and give personal stories and talk about your grievances to the judge all you want, but unless your proof can actually be favorable to you, it's not due process. And then it goes further and it says no subject shall be put out of the protection of the law. So, if there's no way to defend against the no-fault ground, which other states, like in New York, they say explicitly there are no defenses to the no-fault grounds. If you can't provide proof that is favorable to maintaining your marriage status, or if you're not protected in any way because divorce is a foregone conclusion, that's not due process. And if you think about any other legal status, we talk about
I could be a tenant in an apartment.
You're a tenant, your adoption status, citizen naturalization status, military status. All of these legal rights are based on process, right? They all change because of the procedures that change those statuses. So, like the Supreme Court has already said that marriage is such a fundamental right that due process, making sure that you follow the right procedures, is really the only way to protect it. And so you look at the Massachusetts Constitution, which is very explicit that due process requires that not only do you have the right of presenting proof, but the proof has to be such that it could be favorable to your cause or your interests. And
so let me think about marriage. If a woman accused a man of adultery and the woman came forward and said he committed adultery on such and so date with so and so, he's cohabiting with her, then the man could come back and say, wait a minute, that's like my grade school friend. I haven't seen her for a year. He could bring proofs or I haven't seen her for 5 years, whatever. He could bring proofs that's like, well, she's a witness. Here's her preliminary questions that we asked her, whatever it's called, interrogatories submitted to the court, preparing for a trial, where this is an example of someone being able to bring facts that could do whatever you were talking about. Mm-hmm, mm-hmm. Whereas with no fault, here's Mark, his wife says irretrievably broken, and he's like, there's no fact I can bring to defend that. I think she's not. I disagree.
Well, and that also supports his argument that it's a viewpoint-based statute, because the only thing he can do is offer his own viewpoint. There's no other proof that he can really offer. And so the Supreme Court has said that due process requires a meaningful defense, not just a defense, but a meaningful defense.
Okay. Then there was a couple of other things. He started talking about constitutional principles that I've heard vaguely, but I kind of forget what they are. So the bottom of page 5 says something violates the 14th Amendment. Can you remind us what is the 14th Amendment about and what's the principle that he's talking about?
I mean, that is the due process.
Okay, that's the due process one.
It's also equal protection under the law. So you have to be treated equally if you're on equal circumstances. So
okay.
Yeah.
Then,
later he argues basically that all in a no-fault divorce proceeding, that all plaintiffs win and all defendants lose, and so I mean that's that's where he uses that as well.
That's true. That is what happens. So then there was another one, contracting legal marriage. I'm going to skip over Ministerial Act. I'm at page 6 now. Oh, Federal Contract Clause. He touches on this. Let's see. More than this, the U.S. Supreme Court has opined that without the finding of default or assent, the granting of a divorce is a flagrant violation of justice that implicates the violation of the Federal Contract Clause. And then he lists these other things, U.S. Constitution or Article such and so, which I guess is the Federal Contract Clause. Do you know what that is offhand? I'm thinking that the federal government, the states can't make any law infringing on parties' obligations in a contract. Is that what this is?
Yeah, and I'll try to be brief, but this is really important because other people have argued using the contract clause that, oh, marriage is a contract, so you can't break this up. That's a misunderstanding of the contract clause. The contract clause allows states to prescribe grounds that, like any other contract, and this is an important distinction as well, marriage is a civil contract, not a private contract, which is what the Dartmouth case explains. So it's regulated by law, not what the private parties agree to up front. But basically, the Dartmouth case gives 2 exceptions to why it would be applicable to divorce, and one is when any state shall pass an act dissolving all marriage contracts. So basically, if a state decides to abolish marriage in general, which we might be at this point, or number 2 exception, if the state passes an act or a law that enables one spouse to obtain a divorce without default or without mutual consent of the other spouse.
I'm sorry, this is getting...
So if you think...
Is this back to the... This still goes back to the contract clause? There's certain times when states can make laws infringing on obligations of a contract?
If you think about a normal contract, there's only 2 ways to terminate a contract. Either the 2 parties decide mutually that they're going to dissolve the contract, or one party. I'm the tenant in the apartment, and I have an agreement with the tenant. The landlord and the tenant have an agreement. It's understood that after a year, that contract ends, and that was agreed to in the beginning. So that we agreed how it was going to end. Right. So you have that agreement up front. Now you can terminate it beforehand, but only if both of you agree.
Right. Okay. He's going to pay me $1,000 a month to get out sooner because he's got a buyer for his building, or maybe he's going to pay me $5,000 a month. I'm like, okay, I'll take that. So we agree.
Yeah. So you either agree to change the contract, dissolve the contract, or one person doesn't live up to their obligations, right? And so you can also break a contract if the other person doesn't fulfill those obligations.
I don't pay my lease for a long time.
Yeah, exactly. And so the idea of using this in the divorce case is that without agreement, mutual agreements, and without some default of the terms and conditions, that the state is infringing on the obligations, right? So if you think about no fault, under the contract clause, you could have a mutual no fault because both parties agree. I mean, it may be unconstitutional for other reasons, but under the contract clause, both parties agree to end the marriage. Or under fault grounds, one person, the misconduct broke the obligations, right? But the U.S. Supreme Court has given their opinion that, oh, well, if you don't have any fault and you don't have mutual agreements, then the federal contract clause could apply. The federal government can say, state, you can't make a law that allows one spouse to leave without mutual agreement and without any default. And that's really what the Dartmouth case has said. It actually gives an exception to unilateral no fault and says, no, the states can't do that.
Okay, so Mark is referencing this, but it's not a main focus throughout.
The main focus, it looks like, is that it's a viewpoint statute. Yeah.
Okay. And then you talked about mutual consent, viewpoint, mode of contact, opinions. The 14th Amendment is the due process one. You talked about that. Oh, the Establishment Clause. On page 7, paragraph 15, because this is a constitutional challenge against the state statute and not against a decision made by a public official, it is likely that the Establishment Clause is a more appropriate constitutional clause to address this viewpoint-based law. Is Establishment Clause the one that says it might be the federal government cannot establish religions or interfere with the free exercise thereof?
Yeah, I think he was just throwing that in there because there was the Panko case that you reported on that also argued the viewpoint-based statute, but I think he used the Establishment Clause, and so he went the route of, saying, to think that a marriage was irretrievably broken is kind of a secular religion, right? But according to recent case law, it's more of the free speech clause. So I think he was just throwing it in there just in case he would use that later on. But it's the same argument that it's a viewpoint-based statute.
Okay. And then on page 8, he refers to the free speech clause, which you were talking about a little bit before. It's where you and I could talk about what viewpoint discrimination means, and someone could challenge, well, where is that in the Constitution? So it fits under different sections, and that's why page 8, he's talking about free speech clause, because the viewpoint discrimination fits under there?
Yeah.
Okay. Yeah. And then the equal protection clause, you already talked about that. Page 8, I'm looking at the bottom, you've talked about the rights. Well, I guess this is important. I think on page 8, the bottom, if this court grants a divorce by irretrievable breakdown, the defendant will be stripped of several legal rights, including but not limited to his social and legal status of marriage, the society established between him and his wife, any or all pecuniary rights established within the marriage.
Like money, essentially.
Okay.
Property.
Takings, houses and effects, medical rights, taxation benefits, custodial rights, as well as religious freedoms. Why did I circle this?
So he's basically listing off, I mean, not everything because there's too many, but he's listing off, okay, these are the things that the rights that he holds within his marriage that
when
are
you have
going
the
to
status.
be deprived. Yeah.
It goes, because you've talked about the status is kind of the linchpin of all of this, and all of these rights are under the status. So I could think of the example of a tenant. If I'm the tenant in an apartment, I have the right to live there. And I have the right to do whatever the heck I feel like, unless there's something in our contract that says you're not allowed to do that, like, noise after a certain time or whatever. And marriage gives lots of rights, and when they force a divorce, they're interfering with all those rights.
Right, and they can only deprive him of those rights if there's due process. But he's saying there's no due process.
Okay, and then this leads into 18, talking about strict scrutiny, and I do remember something about that, like
that is placing the burden of proof on the state, basically, and it's saying that under certain circumstances, like First Amendment, like fundamental rights, like marriage. Any challenge to subject matter jurisdiction. Strict scrutiny means that there's 3 different tiers of reviewing laws, and rational basis is the lowest, right? The court just kind of looks at it and says, okay, well, it looks constitutional, so I'm not going to look into it too much. But with these things, if you're alleging these very sensitive items, then the court is required to do strict scrutiny, meaning that he really has to scrutinize and do his research and look very closely at the no-fault law to see if it is constitutional. So strict scrutiny means, number one, that he has to really look into it at a higher level, and that he has the burden of proof. The judge, the court has the burden to prove otherwise. If Mark had to prove it, the court could just say, oh, he didn't prove it. But with strict scrutiny, the court has to be the one that proves that he's wrong.
And I remember when I was first learning about strict scrutiny, it hinged on when a legislative body is making laws that infringe on certain types of things, which are these fundamental rights. For example, if a state is going to take a child away from a parent, the right to parent is a very, very serious thing. So they can't just make any laws they kind of feel like and say, well, we got the right to take these kids away because whatever reason they make up, because it's a fundamental right they're interfering with. That's when this particular kind of scrutiny kicks in. And one of the aspects of them fulfilling the criterion for that is that the state is obligated to prove to kind of the public that there was a couple criterion.
Well, there's like 2 or 3 criteria. One is that the law has to serve a public interest, right? So the state has to really be doing this in the greater interest of society, not just, you know, the interest of the parties. Like it has to be serving a public purpose, and it has to be narrowly tailored in such a way that they couldn't achieve that goal in an alternative way.
Yeah. Okay. You know. Good. Very good.
So
I'm glad that, because I figured that stuff is fresher on your mind than it is on my mind.
So for example, I mean, with the no fault issue, I just want to.
That is all I've got that I circled as I was studying this. So we went, an hour and 10 minutes, but that's longer than I envisioned. So for the listeners, the viewers that stuck with us that long, that means that they appreciated what we were talking about. So thank you, Matthew. Do you have any closing? One of the things that Mark had told us when we publicized this story was that if there was anyone else who was interested in making a similar challenge in other states, Mark was asking those people, write me. I mean, he even gave me an email address to have people write him. So do you know him? I mean, I don't know him very well. Do you know him well enough to know, I mean, if someone was to write him...
I've talked to him a few times, and you know, he said he thinks that this, and I agree that this can be challenged in any state under any unilateral no fault law. So you can email him. I think his email is irretrievabledalmeyer, which is his last name, at gmail.com. So a little irony there, but
all right. So I'll put that in the notes about the video, because I want as I was looking, because after he submitted this motion to the court to dismiss, then the court took him seriously. They didn't ignore him, and they said, okay, both parties, you have so many days to submit a brief, which is even another kind of longer document supporting your position. And I printed that one out. It was a bigger font, so it was less words, so I guess that's something they want people to do with briefs. But a section of a brief is all the court cases that are cited throughout the whole brief. And some number of them, I don't know, I would guess maybe a fifth of them are Massachusetts. But somebody who wanted to take this exact same argument, like if I was in Ohio or wherever, was saying you just go find similar kinds of cases that were in the state. But all the stuff that has to do with other states, I mean, he's in Massachusetts, but he's citing New York and Ohio and New Hampshire. So, and
there's
tons of
different
U.S.
tiers of
Constitution.
authority. Yeah, there's different tiers of authority. So something that is in your state versus someone else's state is more authoritative, and something that a Supreme Court versus a lower court is more authoritative. So it's just different levels of authority.
So I just wanted to point that out to any viewer, because you don't need to be that intimidated that, you know, maybe you could, with some help and some coaching, do this in your own state. So I'm happy about this. I'm excited. Thanks for your help, Matthew, in explaining all of this to those who were either the legal minded. I think sometimes we were talking below them, but sometimes we were talking above the average person. So it's all good. Well, I think we're done. Thanks.
Sounds good. Thanks for having me.
All right. Talk to you later. Bye-bye.
All right. Bye.